Hello everyone and welcome to our channel NetLogic. My name is Advocate Pingle and today we are going to discuss about unauthorized copying of data or employer-employee relationship vis-a-vis if you copy intellectual property from your workplace. Do you have any liability? Is it allowed? Is it not allowed as per the current regime under law and so forth? So let's start with it. First of all, we need to understand one basic thing. I have seen many employees coming to me regarding a simple scenario wherein they have copied certain data from the company while resigning the company. Let's understand who is the first owner of the intellectual property when it was created, whether it's you or the employer. When you join a particular company, you always sign an appointment letter. Subsequently, you might also sign an employment agreement and several IT policies. If you look at those policies or that agreement, there will be an intellectual property related clause. What does it mean? So whenever you create something during the course of your employment, the employer will be the owner of that intellectual property, because that work is work for hire as per section 17 of the Copyright Act. The employer will be the first author of that particular work, because once you sign that employment agreement or intellectual property related any document, you are assigning or you are transferring all the rights to that employer. So you need to understand this, that whatever data, whatever information, whatever intellectual property you create during the course of your employment, specifically if the device which was provided by the company, using that device, the owner of that data or that intellectual property is the company. So let's take an example that while resigning from the company, if you copy certain data with you, what is your liability? You might think that that data was not so important for the company. It wasn't any confidential data as such. You just copied some presentations, you just copied some Word file or some Excel file, and it wasn't confidential per se as per you. But you're mistaken. If you copy, irrespective of what file you copied, if you copy even a single file from your company device or your workplace, then you are liable under Information Technology Act as well as Copyright Act. Now section 43 read with section 66 of Information Technology Act gives out specific liability for unauthorized copying of data. The punishment is up to 3 years imprisonment. So obviously you need to be very careful while copying the data from your workplace. You need to be very careful. You need to seek necessary permissions from your manager before doing anything of this sort. And moreover, it's a cognizable offense. What does that mean? That if your company goes ahead and files an FIR against you, then that FIR, that offense is a cognizable offense. Police can directly come to your place. They can arrest you without a warrant, because it's a cognizable offense under IT Act. Now let's consider another scenario wherein the company has provided you your laptop or any device for that matter, and we all are working from home nowadays. You know the situation. So in this current scenario, even if the company hasn't assigned you a specific task or you are not working on any project, and during the course of that employment, if you work on your own thing for your and personal matter, if you create a software or if you write a code using that computer, using that company provided device, then who is the owner of that particular intellectual property? Now to understand this, we need to go and look for the employment agreement. If there is an intellectual property related clause and that clause states that even if you create your personal work using the company provided device, then the company would be the owner of such intellectual property. Obviously, whether that clause is valid or not will be decided by the respective court once it goes before a court. But as far as that clause is concerned, you need to be vigilant enough, you need to properly vet that document or that agreement before signing such agreement with the company. Normal clause states that whatever you create during the course of your employment will be the property of that company. That is absolutely right, because it's a provision under the Copyright Act. So under that provision, it's work for hire, as I said earlier, and company is the owner of that intellectual property. Now, as I said, that many of you do not understand even if you copy a simple file, but the penalty or the punishment remains the same. Now, as far as the employer is concerned, obviously I have seen this lethargic attitude, specifically small to medium sized companies. They do not have agreements in place. Once you go and join any small and medium sized companies, they only or the employer would only give you an appointment letter, and that appointment letter would be the only document between you and the employee. So as far as the employer is concerned, you need to be you need to understand one thing, that employment agreement is very, very important for you, or NDA or IT policies are very important for you. You need that employee to sign all these documents to protect your intellectual property as an employer. You all know that information is today's gold, and you all need to protect your information. You spend lakhs of rupees or millions of dollars on cybersecurity, but you also need to spend a little bit amount on your legal documentation and get that documentation in place to protect your IP, to protect your intellectual property. So I hope that today's video was useful to you, and if you found the video useful and the information helpful, then please do subscribe to our channel for more videos on cybercrime awareness and cybersecurity, and hit that like button and share the video as much as possible. Thank you so much for patiently listening. Thank you.